Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah. Enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things? All the many things you Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are. Lord, you are. You're my everything. Say, I call you Zion. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. Lord, you're my everything. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. Lord, you are. You're my everything. Uya matinyana. Uya matinyana.
Hello, hello, hello. A lovely Saturday afternoon is here with us here in the UK and of course on the program The Community and the Law. We're live on BWTV, we're live on BW Radio. Well, if I look through my window, I see that it's raining. It's a wet Saturday afternoon here in the UK. What about you? Whatever it is, we have the warmth from within that would help us go through the 2 hours that we have in front of us, where we're going to learn so many things, answer our questions, and of course, get to have an interaction with BWF Solicitors. The question I'm asking you today is, did you know that you can request to vary the terms of your employment contract if your circumstances have changed? Well, if you didn't know, I'm going to tell you something real good to learn and something real good to keep in your arsenal so you know what to do at your workplace. Then again, if you have any legal question, if you have any issue bothering your mind, you can come on the program when the phone lines are active. And my guest, Lawyer Charles Asma from BWF Solicitors, will be answering them. Ladies and gentlemen, brothers and sisters, boys and girls, this is The Community and the Law. My name is Owusu Frimpong. Let's all jump into it together. Hello, 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 brothers, sisters, uncles, aunties, friends, and everyone on board. This is BWTV, this is BW Radio. We're live on BWF Solicitors Facebook page, and we're live on BWF Solicitors YouTube page, on LinkedIn and all the social media platforms. It's the second time in the year 2023 that we're coming your way with the program that helps the community understand what the laws are, what they say, and how we can deal with all those. My name is Owusu Frimpong. I'm hosting this program today, and we come your way courtesy BWF Solicitors. BWF Solicitors are legal partners when it comes to the law here in the community. And what they do for us is they have the room, the door, and of course the space for you to bring in your legal questions, legal issues. They will help you with your applications. They will help you with understanding the law, both here in the UK and back home in Ghana, or all the other jurisdictions that they operate in. They have lovely, wonderful legal personalities that will help you understand everything you need to understand. And by their courtesy, we're coming your way with this legal education program spanning between now and 6 o'clock here in the UK. Once again, my name is Owusu Frimpong, and my guest today is I would say my regular Saturday pal, my learned friend and a lawyer from BWF Solicitors. Lawyer Charles Asma is right here with me, and he's going to help me deal with the question I posed earlier on. If you are employed in any organization and your circumstances change, would you be able to ask for a variation in the employment contract you have? Now, first of all, I will go to the basics and ask, what's an employment contract? Who are the parties to any employment contract? And would anybody have the right to change it anytime, anyhow, anywhere? Well, we'll be looking at that. But before then, let's say thank you to BWF Solicitors for going through the art, and they will tell you what they do.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we'll get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well, thank you very much, BWF Solicitors. We know you are our trusted partners when it comes to the law. And this afternoon, we're so privileged again to have you in our midst again, teaching the community and, of course, providing us with all the opportunities to understand what the laws say and what new situations we can find ourselves in. Now, today I'm going to take you through a few examples, so let's get them out of the way. Now, the very first one I'm going to look at is a situation where at the beginning of the year, the beginning of the week, so to speak, when BWF brings out our nuggets. So let's see what they threw at us today. Now, foreign divorce obtained without the court's involvement outside England and Wales is not valid in the UK if one of the parties was habitually resident in the UK or has lived in the UK for 12 months or more or domiciled here. This provision applies to divorces obtained under customary law in Ghana. Now, this is quoted from Section 46.2 FLA 1986. In the case That is Bergovitz versus Greenberg, the Attorney General intervening 1996 case, the FSC or FCR 587, foreign divorce. Now, if you live in the UK and probably you have a partner in Ghana or outside of the UK and you want to divorce, what do? Or you married in the you married outside of the UK and you would want to have a divorce here in the UK. What are the principles about it? What does the law say? This provision, according to what we have on the screen, applies to divorces obtained under customary law in Ghana. Quite confusing, so many things brought together here and there and the rest of it. Now, as part of my introduction, I will be asking the lawyer to look at that for me. But before then, let me also say to you that if you want to apply for a visitor's visa and want to do it correctly and right, you need to contact BWF Solicitors. BWF Solicitors, they are on the 4th floor of the Anna House, 214 to 218, Tottenham High Road in North London, N154NP. Call them 0208 493 7340, 0208 493 7340, or the emergency number 077 127 61884, 077 127 61884. Okay, now I think to get things going and get all those things out of the way, let me bring on Lawyer Charles Asma and I ask what the nugget is all about, the foreign divorce. Now, somebody unfortunately may have to terminate the marriage contractual agreement, and you're doing it. What makes one a foreign one? What makes one a local one, or whatever it is? Lawyer Charles Asma, good afternoon once again.
Thank you. Good afternoon, Rakuku.
How are you?
Yeah, great. How are you too?
Yeah, well, very well. By God's grace, another Saturday has come to meet us, and we're still alive. By His grace, we're doing very well. Quickly, let me ask this, that we don't expect that whatever it is, the situation will go bad. Because people get into marriage and it's about love, it's about procreation, creating a family and enjoying life. But it gets to a point where it has to go bad and the two parties will go their separate ways. But the law, I know because of the seriousness of divorce, the bitterness that people express for each other, and some of the consequences, the law has to regulate divorce. But I'm hearing foreign divorce. Is there a difference between what is foreign and what is local? What's divorce in itself?
Thank you very much. Yes, so viewers and listeners, once again, good afternoon. We are discussing a very important nugget point, and the point is if you are married per the customs of your country or land, and you wish to terminate the marital agreement, how do you do it? And is it always acceptable in the UK in terms of how you go about it? First off, marriage is between two people with a blessing of the families. So we can say between two families.
Okay.
Once the families agree, there is...
Is that a universal principle?
Of course, marriage is between two people who have understanding that they come together to live each other's life forever, so to speak.
Right.
And with that, families are involved.
Okay.
So every country has its own customary laws that regulate marriage. And the case in point is that of Ghana. So Ghanaian customary marriage laws are quite clear that the marriage is put together between the two families.
Okay.
And once the families have agreed and the parties are happy with that, there is marriage.
Okay.
All the rituals come together, there is marriage. What it means is that once that marriage is performed, any other documentary evidence that you wish to have to support that marriage that has already taken place at home through the families, you go to the government body responsible for registering, acknowledging the marriage, and that's the registration.
Right.
So in Ghana, for instance, you go through the registration under the Customary Marriages Act. So we have it's an old law, 1885 law, and we also have an Cap 127 law, the ordinance marriage. Either way, the families have agreed, you register your marriage. Once the marriage is registered, there is partnership.
Okay.
To break the partnership means both parties must consent to that separation.
Okay.
Otherwise, it will be easy for anybody to just wake up and say, that's the end of it. Then that will not be fair at the other party.
Right.
So the position in UK under Section 46 of the Family Law Act is that you have to go through the court process.
Okay.
So that both parties are aware. And so that if one of them want to contest, then they will contest. And if the court says so, that will be it. Now, let's take it that because it is customarily, the families have agreed that the marriage cannot continue to exist because of some factors that have made the breakdown of the relationship irretrievable.
Okay.
And the families have agreed that we have to exchange, the dowries have been exchanged, but we have to return
Those
the drink
dowries. Okay.
and whatever was given to seal the relationship or the marriage. The families will say so, and so be it that there is separation. However, it will be easy for any family member to support the other family member to say that, you know what, get out of it, let the other person go his or her way. So it has to go through the court process.
Okay.
Going through the court process means you have to make application to court so that the other party can respond if they have to. If they agree to it, then smooth process. If they don't agree to it, then it has to be contested until the court pronounces that. What it means is that if the family agree that the marriage should be over, and you go to a local council or assembly for them to give you a letter to confirm that that is not the type of divorce or separation or dissolution that is allowed.
Okay.
Now, we are looking at this in terms of those who need that evidence to support their immigration application.
Okay. All right.
So somebody is married, they are divorced. It was okay, if you are married before, you should have divorced before you can marry again. So they go get a letter from the local assembly and they say, this is my divorce. Now the position has changed. The position is that if one of the parties is living in the UK, habitual, the word is habitual residence. What it means is that you are living in the UK 12 months or more, then you are ordinarily living resident in the UK. You are not just a visitor in and
So
out.
in that case, if you are habitually resident in the UK or ordinarily living here or domiciled here, the laws that apply here are the laws that you have to use to dissolve the marriage.
To dissolve the marriage. Okay. So the position is that if you are living here and you say that your marriage that took place in your country has been dissolved, then they expect you to go through the process that is enshrined in the UK law,
okay,
which is the Section 46 that we talked about. There's also case law provision, the case that we refer to. There's also a local case, which is the case of Boche and Abrifa. These are Ghanaian partners who took their issue to court, and the court concluded that this is 2021 judgment, that if one party is habitually resident in the UK or domiciled, so domiciled would be somebody who has settled status or citizenship. Habitual resident, you may have 2.5 or limited leave to remain, but all your life you live here. So 12 months plus you are living in the UK. Then we say you are habitually resident. In this case, you have to follow through the law.
So can there be any situation where there is a full court process, say back in Ghana, to dissolve the marriage, even though habitually one of the partners may be living outside of Ghana and, for example, in the UK? Can't they accept that the laws in Ghana they have gone through the process properly and a judge has pronounced it.
That is what the law is requesting.
Okay.
That is the whole essence of this nugget. That you cannot just go and get a letter from a local assembly to say that the marriage has been dissolved at home and this is the evidence of dissolution. It has to go through court process.
Okay.
The nugget position doesn't say that it has to be in UK court. It says it has to go through court process.
Okay.
So it can take place in your original home country, or it can take place in your second home country, which is the UK, because one of the parties is habitually resident.
In the
So you can get the divorce done in the UK, or you can also get it done in Ghana. Either way, in the UK, you cannot just get divorce accepted by just going to the local assembly council to get a letter that this is, or something to show that it's, no, you have to go through the court process. And that is what they expect to happen wherever the divorce is taking place or coming from.
Okay. Well, brothers and sisters, folks, Lawyer Charles Osman has been gracious to explain the detail to us. Now, what the nugget says, it's about foreign divorce, and it says that foreign divorce obtained without the court's involvement outside England and Wales is not valid in the UK if one of the parties was habitually resident in the UK or has lived in the UK for 12 months or more or domiciled here. The provision also applies to divorces obtained under customary law. For instance, in Ghana, Section 46(2) FLA 1986. And I remember lawyer also mentioning a case in 2021 between two Ghanaians, and that confirms that as well. Another thing that lawyer has come up, and I would want you to quickly look at that for us. It's there is news that people can get faster decision on visa or settlement application. What's happening?
Yes, we thank you very much for graciously sharing this. I'm sure viewers can see, and if you follow the link, it will tell you that from the 9th of January 2021, what used to be called fast track has come back. Okay. In that, if you want it fast tracked, of course, now we have the premium service that people have been accessing. Within a day, you get your decision, provided you have the purchasing power. It's not about affordability. But it's good because you are looking at cost and benefit.
Okay.
Trading £800 different for...
£800?
Yeah, yes, so that's the extra.
That's quite a lot.
So that's if you want it the next day, £800. Imagine you are paying £800. And it's going to save you the hell or the trauma or the inconvenience of having to wait for 1 or more years. Which one is better?
Anyway.
Exactly. You need it to be able to. So by the end of, so if you are getting it the next day and you are paying 800, you've got it within 1 week. The rest of the period, let's say 1 year, a year's time, which is 52 weeks, you realize that you can work and recoup your £800, can't you?
Well,
so that is the good side, and that is how I want people to understand. It's not always the cost, but also the benefit.
The benefit of it.
So what the government is saying is that if you are making an application, settlement application in the UK or outside the UK, of course, the cost structure as we have is the ones that are made, applications made in the UK. So you are making an application in the UK with your families or yourself. We have 2 options. Either you go for medium time or the super time. The super time decision is made within 24 hours, the next working day, after you've done your biometric. That means soon as you finish your biometric, decision follows. There are instances where you can even use the ID app so that you don't even have to go and do biometric at all. Okay. But either way, you get your decision as soon as possible, so you pay £800. The other one, if you want it a little cheaper, you pay £500 for each application, and that decision is to be made within 5 working days. Okay. So if you made the application on Monday, by the next week, Monday, 5 working days, you have your decision.
Okay.
And that's quite helpful. Now, what the policy change is also saying is that if you are doing it with family members, you have to be mindful that you cannot cherry pick. So that you can't say that there are 5 of us, I, my partner, and 3 kids, and therefore mine is an emergency, but the kids are not too serious. So I will take I will pay 800 for the next day, and the rest will go for the standard one, and some of them will go. No, it has to be uniform. Okay. So you cannot pick and choose. Once you decide that one of them needs to be prioritized, then all of you must be prioritized. That's one bit. What it means is that if there are 5 of you, that will be plus £800 each. If I say plus, what it means is that you have your standard fee that you pay, plus the premium fee of either £800 or £500, depending on which option you go for. And these apply to settlement applications in the UK, applies to student visa applications in the UK, skilled worker applications in the UK, and so many other applications that can be found once you follow the link on the screen.
Right, so the link is www.gov.uk/faster-decision-visa-settlement. www.gov.uk/faster-decision-visa-settlement. I know Sandra has graciously put the link in the chat. So those of you on the chat and on the platform, you can pick that and make use of that. And well, as I said, I don't make any excuses when it comes to BWF Solicitors because they provide us with very up-to-date and on-point information. Well, ladies and gentlemen, now coming back to
I might also add that there is also provision for those who are making applications, settlement applications, or skilled worker applications, or student applications from abroad, that you can to opt for priority. Sometimes it's not available, but oftentimes it's also available. That you pay extra £250 to get a priority, which is decision is made within a week. Okay. And that is for those who need to enter as soon as possible from abroad and they cannot wait for a standard decision time.
Okay. Well, those of you who have come online, let me acknowledge you. Sandra Fraser, first of all, thank you very much for that kind of support. You're doing so very well. Henry Vlad Norte, thank you. Henry Vlad Norte, you are here with us. Akwaba, you say. We have PAAM TV UK. Pastor Augustine, thank you very much. I believe we're live on your platform as well. Thank you for spreading the news. Next, we have Sandra Fraser is here. Antobam is on board. Rebecca Mwako, Kenneth Kofi, Furibuating, that's my Antobam I'm talking about. William Adolfo, we have Mehdi Rihodoi. Nana Poku Ajma, you're watching. Odesheba Nana Kweku Meye Dede, you are also on board. Bless Sink, you also watching. Perpetual, you have a question. I will pick it up later on. You're talking about applying for a spousal visa in Ghana, and you want to find out a few things about that. We'll be looking at that very soon. Yvonne also answer, bless you. Thank you very much. Text Christine, thank you. Kirsten Diaz, Verequia Minta, Mohamed Akua, Charles Asma. Is it the Charles Asma I have on the platform?
Really?
Okay. So Francis Bokufofi, Smith Mercy. Somebody says Mensuma Landio. Yes, Mercy. I see you too. Thank you very much. Now, when you come on board, do 2 quick things for me. 1, like the page. 2, pick up the link and share in your network. Then again, maybe a third one. Subscribe to the channel and let us grow it together. Now, today David Koshi, you are here. Thank you very much. Sandra Fraser says, contact specialist immigration lawyers and solicitors for assistance, and all the numbers are there. BWF Solicitors, 4th floor, Anna House, 214-218, Tottenham High Road, 7 Sisters, North London, N15 4NP. Call them 0208 493-7340 or 077 127-61884. Now, today my question is a very interesting one. What I am asking, lawyer, or I'm asking you, and with that, I'm inviting you to join the conversation. Your text number 07950422780, 07950422780, or when the lines are active and I ask you to call 0208 123 1016, 0208 123 1016. I didn't say call now, so don't do it now. Or you can call the mobile 07399 208 468, 07399 208 468. Okay, we're back, and I'm going straight into the discussion. I'm asking, what is an employment contract? What parties are there in there? And the question I have been asked is that, did I know that I could request to vary the terms of my employment contract when my circumstances change? Well, what's an employment contract?
Thank you very much. So we have case law definition and also the statutory definition. The statutory in point is the Employment Rights Act 1996, and this is a UK law. There are also case law views. Now, so to speak, under Section 230 of the Employment Rights Act 1996, employment is mainly a service, and it's a form of contract between two parties, where one accepts to provide, in other words, one accepts to serve the other party, and the other party accepts to provide jobs or service for the other party to do. And this is a simple way I'll put it, because I don't want to be too legalistic. Now,
but you're a lawyer, so we can excuse you.
So employment contract then comes in when there is this agreement between the person who accepts and the person who offers. So there's offer and acceptance. One offers a service and the other accepts the service.
Okay.
And the service can be permanently or temporarily.
Okay.
Now, these days we have a range of categories of people who qualify as employees. So if you go under 230 that we refer to, we have definition of that, who an employee is.
Okay.
And also we have other people such as workers, agency staff, and so on and so forth. But we are putting all together as employees. Now, if an employee, you have the employer agreeing to do something for you and you agreeing to perform something for the employer. That employment contract has to be validated by way of written agreement. So under Section 1 of the Employment Rights Act 1996, there must be what we call terms and conditions, or terms of the agreement or the contract. So you have that. So the question here is, at what point in time can I seek to vary this agreement? Because ordinarily, once you enter into agreement, the terms must subsist.
Now, let me look at it before we go into the variation of the terms. A contract should have a start and an end, doesn't it? So if I get employed, does the employer have to give me a number of years that I can work at that position and in that employ?
So the agreement or the contract will specify the duration of that agreement. So as I said, it can be permanent. That means you don't have any definite ending. If it is temporary, then there is definite ending. So at the end of that definite period, the contract is over. Of course, subject to renewal, but if it's not to be renewed, then we say the contract is over. So you can go for 1 year contract, 2 year contract, short-term contract, whatever it is. You know that it will end at a point because the contract will say so.
Okay.
If the contract doesn't give you definite end period, then it's permanent, and it will specify that this is a permanent contract.
Somebody is here sent in a very interesting question. I was just looking at that, and it says sometimes they say 0-hour contract. What is that? Does it have an end or a start?
Right. So a 0-hour contract means that, so the word is there, hour. So where the hour is not qualified, then we know that we are looking at the standard hours of 37 a week or whatever a week. But the moment you have 0-hour contract, what we are saying is that you don't have specific time or number of hours that we expect you to work every week.
Okay.
Such that if that hour is not provided for you to perform, the employer will be at fault.
Okay.
Yours is 0. So at any point in time, you expect to work 0 hours. Where we need you, we'll call you to come and do more than 0 hours.
Oh, so but 0 is not absolute.
But 0 is 0. 0 is a number.
Okay.
Yeah, 0 is a number. So in this case, you are working 0 hours, so your contract is 0 hours. So you don't expect the employer to compulsorily offer you hours as would have been if it wasn't a 0-hour contract.
So when I have a 0-hour contract, I can refuse to work.
I mean, I suppose you would want to work. So it's more in favor of the employer than the employee. So you have a 0-hour contract, and at any point in time, the employer will ask you if there's job available. And I'm sure you every day will be asking, is there a job
if
for
there's
me?
more
Is there a
for
job
me in the rest of the year.
And if you are needed, you can do more than even the 37 hours. But once there's no work.
So per verse, the understanding could be that if I have a 0-hour contract, then I'm not restricted to working 37.5 hours or 35 hours or whatever. I could do any number provided there's work available.
Exactly.
Oh, okay.
Exactly.
Yeah, I'd rather go for a very high contract.
What? Depending on your circumstances, isn't it? So people go for 0-hour contract,
Right.
but sometimes 0-hour contract is flexible.
Okay.
Depending on the nature of the service. Sometimes some of these services are seasonal, so you do so much, and at a point nothing is happening. But at least you have contract with the employer that when there is availability, you will be first to be considered.
Okay. Now, what goes into any employment contract? I'm asking because we will be moving to the point where we're thinking of varying the terms of the contract when my circumstances change. What typically goes into an employment contract? Okay,
so thank you very much. So if we look at Section 1 of the Employment Rights Act 1996, talking about terms of the agreement or terms of the contract, you are looking at the parties involved. So A and X, or A and B, X and Y, let me put it that way, X and Y. So X is the employer, Y is the employee. So the names are clear. Okay. We know who is involved. We also have the place that the service is to be provided or work to be performed. So let's call it the workplace.
Okay.
So the employer will specify the workplace, and the employee or the will-be employee will accept to perform the service from that workplace. We also have the duration of that service, as I said, specific period or permanent period. We also have the time the employee ought to start work.
Okay.
We also have the hours the employee ought to work. We also have, we've already mentioned the place. Then we have the wage or the remuneration
Okay.
that ought to go with that service. We also have other things that the employee ought to know and follow, what we call code of conduct.
Okay.
There will be policies in place that the employee ought to follow. So any other thing that is clearly specified will be the primary contract or primary terms. Then there will be secondary terms. But the key thing within the primary terms is, are such that they ought to be provided before the employee starts or the first day the employee has started work.
Okay. So when my employment contract is laid before me, I should be looking for where to work, the times that I need to work, for the benefits I will get from it.
How many hours?
How many hours?
Expected to work a week.
Okay.
And also a day.
Okay.
The break and the holiday leave, all those things.
Okay. So holidays and all the other benefits that come with it.
Yes.
Would you be me providing the service or going to the employee of that person? Would I be, or would I have the opportunity of telling the employer that I want X, Y, Z instead of what you have put in there before I even start?
I suppose you need work and you have examined yourself that you fit what has been laid before you. You apply for the job based on the job description. You've been interviewed and you accept, you think through and you sign the contract. At that point, it is what you have accepted. However, things change, and that is what we are looking at. What happens after some time your circumstance has changed? Can you request to vary it?
Obviously, when we talk about circumstances, we're talking about some physical circumstances. But things like where I live, my health conditions, or even economic conditions can all change. What should change before I can request for a change like that, if it so happens?
So here we are looking at moving from fixed or rigid working pattern to a flexible working pattern.
Okay.
So section 80, G, F, H, I is where we are going to base our discussion on. But the first part or the first point is looking at section 80F of the Employment Right Act. And that is where it says that where the person's circumstance has changed, the person will have the right to request to vary the contract, the terms of the contract. And here, I don't think anybody would want to request to vary their pay downward.
No.
And the employer will not accept
never.
upward. So there will be no contemplation to vary the pay. So the benefits may not necessarily be varied, but you seek to vary the duties and how you play out the duty. So let's say your duty is to work 37 or 40 hours a week. And for some family reasons, personal reasons, career reasons, educational reasons, some other reasons, you cannot cope with that 37 and a half hours a week or 37 hours a week or 40 hours a week. So you tell your employer that my circumstances have changed and therefore I will not be able to do this number of hours a week. Then you have to rely on section 80F to start the process. Or you are doing full time, 5 days a week, Monday to Friday. For whatever reason, you cannot do Monday to Friday. So you have to make a request under section 80F to the employer that for these reasons, I cannot do 5 days a week. So you are varying the scope of your work pattern.
Right.
Or, obviously, there are instances, so we are not talking about place, because place may be so fixed that you cannot seek to vary the place. You cannot choose where you want to work. The employer will make a suggestion to you that we are moving you from here to that, but that is also a variation. In that case, it's up to you
to accept it,
based on the discussions with the employer to take it from there. But we are looking at few or one or two things: hours, days, and also so hours and actually days.
Okay, so the unfortunate happening of COVID made so many things change. Now, somebody who was asked to self-isolate and all went on lockdown, people or some organizations are faced they're coming back into offices into certain new arrangements of working. Now, if, for instance, I am apprehensive of getting into a large crowd in an office area, can I request that because of the COVID circumstance, things have changed on my part, so I would want to work from home all the time? Would that be an acceptable something?
So that is one of the variations that you can seek to make to the employer. So under the provision that we are looking at, it says that the first thing you can ask for is the hours required to work. We're also looking at the times when the person is required to work. So how many days a week, and the hours, how many hours a week, and also where between his home and the place of business of his employer he's required to work. So imagine the employer has many working places or points. As part of the variation, you can make a request to say that because of my circumstance, instead of working at point Z, I would wish to be considered for point B. That's also, then you are varying your contract, because your original contract might have stated that the place of work will be point Z. Let's say your place of work will be Liverpool Street, and there is a new office at, let's say, Stratford. You can request for your contract to be varied so that you will be working at this place instead of the original place.
Okay. Now, the other question I would want to pose is, if I ask for a variation, can it be a temporary something where if another circumstance or even the same circumstance that has changed, that has warranted me to ask for the variation, if it changes back to the previous one, can I still ask for a variation? Or if I ask for one variation, it has to be a permanent or a long-term something?
So the law doesn't spell out how long that should be. So we apply business and what we call commercial sense to assess whether if you take flexible work pattern, it should be permanent or it should be up to a point. And again, we get to a point where even the application for variation ought to be considered by the employer, and the employer will have to make a decision based on certain factors. So it's not a case of you make application and that's it, the employer says no, and you are taking the employer to court. No. So, but the point is that if you make application, you have to specify how long that variation should be.
Okay.
And what sort of variation you are seeking. Some people will go for, let's say, 1 year. Some people will go for a specific period. Some may say, I want it forever, so the contract will change completely to reflect that. Now, once you do that, can you come back and make another variation? The law says you can request to vary. What it means is that you can request to vary whenever you need to request to vary. It doesn't tell you that you can request to vary once, twice, or does
a law provide any situation where the employer can say no?
The employer, so that's why I said that the employer will have a duty to make assessment of your request and conclude based on informed factors that your application will be accepted or not. And the duty under Section 80G is for the employer to make a holistic assessment. And I'm going to take viewers through some of the things the law requires the employer to consider. So that when the employer considers those things, you cannot, as an employee, say that, oh, the employer has not been fair, for example. So if we go to G, and this is very important.
Okay.
The law says that to refuse the application or to grant the application, the employer must take into consideration certain factors.
What are?
The factors will be the burden of additional cost.
Okay.
Burden of additional cost. So if you are not there, there's likely to be additional cost because your extra work might be covered permanently or temporarily by somebody else. So that's additional cost. Somebody will say, but if the person is not there, they are losing anyway, so why can't that fraction be given to the new person? But that new person will also go through training and statutory duties on the employer in terms of NI, national insurance and pensions and so on and so forth. So the first person is there, second person is there doing the same job because half-half. But in terms of pension and all that, it will not be half-half because they are both working. So their rights ought to be respected. So the employer will consider the burden in terms of cost on the business. Again, detriment effect on the ability to meet customer demand, so business needs. If this is granted, will it affect our ability to meet customer needs or demand? If that is going to be the case, then it is likely that the employer will make an exception to that. Again, inability to reorganize work among existing staff. So if the employer is not able to reorganize the work among existing staff, then request for variation or flexible work may not be granted.
Okay.
Again, detriment impact on quality. So if you are not there, somebody will have to cover your bit. And if that's going to affect quality, then the employer may be skeptical about granting your request. Again, we are looking at insufficiency of work during the period the employee proposes to work. So let's say you work 5 days a week, weekday, and you now propose to work weekend. If there's no job for weekend, the employer will decline the application.
Okay.
So when you are making your application as an employee, you have to factor in these possibilities and preempt, because the law requires you to also say how you expect the employer to meet these things.
Okay.
So yes, you've made the application. They also point it out to the employer that I'm aware that this will bring or this will have impact on business. Therefore, these are my proposals to mitigate that effect.
Okay.
Then, so here, what you are doing is to support the employer to say yes, because you've allowed the employer to cover their duties. So you may make a suggestion, you may do this, you may do that, but the employer is the one who has to make the assessment and grant or not to grant.
Lawyer, when anybody is entering into any contractual situation, the conditions around it are spelled out. I'm going to employ you. I expect you to do X, Y, Z. You are expected to receive X, Y, Z also from me for providing your service. Now, these conditions that you have outlined, where the rights of the employee to have the variation made when circumstances change, are they supposed to be included in the employment contract that I'll sign?
No. So there is statutory right and the employment rights. So the employment rights are, if I say employment right, I'm talking about the contractual rights. The contract is there, X, Y, Z are stated. That's all you need.
Okay.
However, there is also law that supports the enforcement of that agreement.
Right.
So the agreement is not performed in vacuum. It's performed within the remit of the law. That is why, even though we don't say that you can go flexible, there will be policies in place based on what the law says that there should be flexibility. So the employer will have to have a flexible working policy telling you how to go about it within the remit of the law.
Okay.
The employer will have policy telling you how, if you want, for example, to terminate your agreement or end your agreement contract, how to go about it. Of course, the contract will spell out notice period, but there's also a policy that will carve out how the steps to follow if you want to do this or you want to do that. So the contract wouldn't say, the law says you can do this, so do it. Of course, if the law says, then you know what the law says, and therefore it's your right that you can accept.
Okay. So then, generally, for the ordinary person, what we can be assured of is that if my circumstances change, I can go to my employer and ask for a variation of my contract.
Yes.
And the employer has to go through and check these criteria and see if it is possible to vary that.
Yes.
If it doesn't happen, what do I do? What are my remedial steps?
Right. I mean, if it doesn't, so the position of the law is that the employer has to make the assessment and respond within 3 months from the date of that request.
Okay.
And response ought to be reasonable. Mm-hmm. That is where your next step will determine whether it is reasonable or not reasonable. Mm-hmm. So let's say the employer says that we cannot grant it and there's no reason, then that's not reasonable.
Okay.
If the employer says we cannot grant it because losing you for 2 days will affect business because you play a vital role, and we cannot guarantee that the person coming on board will be able to meet the quality standards expected, you can say train them and let them do it. But then it becomes a case of maybe we won't grant it now, we'll defer it on. Mm-hmm. But it's also a case of, there are also instances where the employer can delay the response per agreement with the employee. So the employer can say that, all right, ordinarily we have to make a decision in 3 months, but in your application or with this particular application, we cannot decide in 3 months. So let's give ourselves, say, 6 months to be able to look at completely. We are considering X, Y, Z to fall in place so that we can make informed decision on your application. That's also required under the law. So the employer can ask for extension of time to make that decision. So you can't say 3 months and therefore they have to decide in 3 months. But if all else is done and the employer has not been able to agree without any reasonable justification, then the employee can take action.
Okay. We'll come back to the action that could be taken, but ladies and gentlemen, Lawyer Charles Asma from BWF Solicitors is taking us through what we can do when our circumstances change and we have a contract of employment that we would want to have varied. Yes, you have the right to ask for the variation. The employer has the right to look at certain situations and conditions and agree or disagree to your request. Your questions and concerns are invited now. You can text 07950422780, 07950422780, or you can call in 0208-123-1016. Remember, we're coming your way courtesy BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, 4th floor of the Anna House. Now, if you're driving, your postcode is N15 for NP. Or if you're going via public transport, you go via train, Victoria Line, Seven Sisters Station, use exit number 2. Exit number 2 takes you to the doorstep of Anna House. Go to the 4th floor, they are there, Monday to Friday, between 9:30 in the morning and 6 p.m. in the evening. If you have any emergency and you want to call 077-127-61884, 077-127-61884. BWF Solicitors are trusted legal partners when it comes to the law. Now, finally, before I allow anybody from outside the studio to join us, let me ask, for instance, if I am fully able to do anything, but due to an unforeseen circumstance, an accident, something has happened, and I'm disabled one way or the other, I'm still able to perform my duties, but I need some adjustments made for my access to the workplace and the rest of it. Is the employer obliged to heed to my request, or they can say that we are not financially in a position to be able to vary our working conditions for you, so we are laying you off. If my employer says so, are they right?
They are wrong. Because the employer has a statutory duty in two breaths. First breath is that there is duty under Quality Act 2010 to meet the needs of people who are disabled. Mm-hmm. So that is there. You have to provide equal opportunity for them to meet expectation.
Okay.
And again, we come to the second breath under Employment Right Act 1996. Mm-hmm. You have to make reasonable adjustment when the circumstance of the employee changes. Okay. So if the person is disabled, then you have to make reasonable adjustment for them to perform. If the person is pregnant, you have to make reasonable adjustment for them to perform. If the person is going through any form of change, then you have to make reasonable adjustment. But from the specific question you asked, if there's disability, it even increases the threshold of duty for the employer, because you have to make it easy for the employee. And you cannot just say that they can't perform. If they can't perform, it means you cannot perform your job.
It provides us with a very difficult situation because, for instance, if I don't have enough funds to vary my workplace, what do I do as an employer?
It's not a case of if. It's a statutory obligation to make reasonable adjustment for that employee whose situation has changed, to the effect that without that adjustment, they cannot perform reasonably.
Okay.
So let's say an employer has back injury. Then you have to make reasonable adjustment in terms of seating. Mm-hmm. If you have to change the seat, you have to change the seat.
I hope my seat is comfortable for you.
This is comfortable. You have to change the seat.
Right.
These days, because of IT systems, even the screen, you've got to make reasonable adjustment to the screen so that it doesn't affect in terms of training, making employee, even the employee knows. But it is also a duty of the employer to ensure that in terms of compliance with their own duty, these are in place. Again, if it's a case of somebody who is disabled, especially they were not disabled and now they are disabled, in terms of to the effect that they have to use wheelchair, for example, what do you do? This is where I agree with you that it can be very contentious because imagine we were working on, let's say it's a story building, and let's say we are on a first floor, and this employee was able to move without any issue. There's no lift, and all of a sudden they can't. Then two options, isn't it? You can't create lift, but you still have to make sure that they perform. It means you have to find a way to move them to another place. If it's a case of getting a place for them ground floor, so that they will not injure themselves further getting to where they are.
Right.
So some of these things can be very difficult for the employer in terms of cost, but it's a matter of cost and compliance, isn't it? Mm-hmm. Will you have an excuse?
You choose between the devil and the deep blue sea.
Exactly.
Right.
So that is the reasonable adjustment threshold for employers.
Okay. Well, somebody's asking for the text number 07950422780. 07950422780. Teleduma, Dorcas, Gurav Singh, MD Rakib, Diana Sapon, Naomi Boami. You asked for the text number, I think, provided, and my studio director has graciously put it on the screen for us. There's a question from Covenant Grace. Let me see if we can pick that one up. What are the differences between the following services? Premium service, priority service, super priority service. Which service is for which application? Example, Premium services are for the visit visa, work permit, indefinite or naturalization. Priority services are for spouse visa extension and the like. Please indicate us which service is for which application.
It's about how much you can afford.
Okay.
So, for example, under the skilled worker provision, there are 3 layers. First layer is standard, and that costs you £247.
Right.
Second layer, they call it priority, and that costs you £747. The third layer, they call it super priority, and that will cost you £1,047.
So the jargons and the names and expressions
Call it-
are all,
so
are
these
all
are-
marketing tools.
Yeah, so this is the pricing name.
Anyway, let's go on to the phone line 07399208468 or 0208-123-1016. We have somebody on the line. Hello.
Hello, good evening, Kofi.
Good evening, boss.
How are you? I'm Lawyer Asma.
Very well, thank you.
Good. I have a pending question that it doesn't relate to employment law, though. So is it possible to ask that question?
Yeah,
It's
please
more
go
to
ahead.
do with immigration.
Yes, go ahead, please.
Oh, okay. My question is on visas application. Applying
Visit visa, right?
Yes, please.
Okay.
So my current understanding is there is no legal basis to appeal or do administrative right. However, if you feel the EC decision is not it's based on an error, can you make a further application between maybe a day or two while the decision is out to explain yourself again for the same purpose?
Yes, so that's the right thing to do. As to when to make another application, it's entirely the applicant's call. You can apply the next day you received your decision, or you can wait and regroup before you make another application. But it's always a good practice that you address the so-called concern that they raised in the refusal decision and address that in your next application. You know, even though you are not going to add a letter, if you are doing your own application, there's always opportunity to say more, because there's a box called additional information. And additional information is not there for
Just
fun.
for the sake of it, yeah.
It is there so that if you have point to raise, to buttress the information you have already provided, this is where to put it. So you can do that using the additional information box to explain yourself. You can also add a letter to address the point raised. However, you see, visitors applications are discretionary applications.
Okay.
So that the caseworker will make a decision based on what they think you will do when you arrive in the UK. If they think that you will not return, they will say you have not met the returnability test. If they think that you will return, they will say, yes, go and come. So unfortunately, there's no strict criteria like other visas where you tick all the boxes and you know you are there. With visit visa, you are visiting the person and it says, don't come yet. You see, that is what it is. But if everything is on point and you can prove that when you come or go, you will return to continue life where you were, then oftentimes they will grant it.
Right. Thank you so much.
All right, thank you too. I think we have one text from Perpetual on the platform. Let's pick that one up. Good evening, lawyer. Is it true that anyone applying for a spousal visa in Ghana has to provide Ghana police report?
Applying for what visa?
A spousal visa.
Well, you know, there are different spousal visas. Students can apply based on as dependent student, spouse. Skilled workers do and all that. The essence of the police report is to help you to make a case for the job you are coming to do.
Okay.
There are people, if, for example, I am a British citizen or settled person and I'm inviting my spouse to join me. My spouse doesn't have to do police clearance
Okay.
or obtain police report because my spouse wouldn't need it for anything.
Okay.
But if my spouse is coming here to perform a particular job that requires that their criminal background is assessed, I mean not criminal background, their background is assessed for criminal activity, then they will need that report. So I would say it depends on what the spousal application is for and whether the person will need, let's call it DBS from abroad at this stage.
Okay. Well, one from Mame Dakua. Mame Dakua says that I have a friend who is in Austria and wants to come to the UK to work. Since the UK is no more in the EU, how can she get her national insurance number when she comes to the UK?
The question maybe should be, can she come to the UK to work? Then we talk about national insurance number. But because as our friend Riley pointed out, there's Brexit since 31st December 2020. So after that, you cannot come in to work. You can only come as a visitor and return.
Okay.
So our friend in Austria who wants to come to the UK cannot come based on EU rights. Unless they were here before, and of course they've already been granted, then it's a case of returning. In this case, they would have already obtained an NI. So the person cannot come and work, and therefore they wouldn't be issued with an NI.
Okay. 0739920848. Yes, lawyer, you wanted to add
So, I mean, unless, of course, the person has a spouse in the UK who is a relevant national, EU national. In other words, the person came before the deadline and has been granted either pre-settled or settled, and they want to invite that spouse, then, or if this person is a child, that child, then of course, when that person comes, they will need NI. So it depends on how they are coming and whether they will require NI.
Okay.
If they will require NI, then they make application for NI once they come.
All right. 0739920848 or text 0795042278. We have somebody on the line. Hello.
Hello.
Good evening, boss. What do you say?
Chair, lawyer, I'm so. Mimio, Namuzoe.
Yami Adumboko. Bajawani.
Me paso your friend Kofi.
Kofi?
Kofi, me kasa fili.
Yo, Kofi, bacho yitu.
Yo, me paso. Let me say, like I say, me represent me our court. Na me represent section 84 of the Immigration Act. And I'm taking number one, me, but lawyer, my sign declaration. Me was also a messiah. Now, say me can present me. I'm a senior lawyer, but me no from this court. Media to say I'm the rep from the courts. Tribunal first, tribunal maybe after in Nigeria. I'm representing. Me now, but I'm not could do judgment or also no. Now they are betting on my case. And she, I mean, you are not also because I know me, you or say it's a consent to him or making that right that was. Now, so, and she asked, not to be sorry with that. I said, I meant to represent me as my rep, Abra. Maybe be able to say, you do understand. The court, the court, listen, only you and Miss Me as a rep.
Yeah, also.
Yeah, that's what I try to say.
Hey, you announce where?
And he also signed section 84 form no.
Yes,
Now
but
take his
the first one. Okay.
Well, into first one was saying form that we need.
Form the money.
Read the first one was saying.
A no, or say A or B. It no say I am appearing in the court. I am appearing in the cases of any, not in the case of any business, paid or unpaid. I am not making any change for representing the applicant. My relationship with the applicant is she's my sister. I am a trustee.
Well, it might be that you misinterpreted point now because usually people can represent, we have what we call legal friend or Mackenzie friend, and but technicality no form no eso. Even if you are a lawyer, now one prepare form ni na one sign one farmer judge now, the judge will not allow you to speak because it's a statutory provision. Say as I say, we yes sir, there no answer ya ma kwan ama wakasa. Nti ekosi saying, o ma wankasa sir.
But me Mr. Now, I'm Mr. to say.
Mr. Intekosi saying, o ma wankasa na ekosi saying, o mo agene ade no ana say, o hearing no.
I say, no. Agenda out there, no, we keep different directions. Now, the different directions necessary. Me some documents no want to na SSM million or in the person or a man of 5 years or tested no Emra court will be. Nam some come home of 40 billion. I feel no sending na ba wo ma date sending na ba na o ma case management. I think I clarify say maybe to me I represent Minua Bana. And Sana, I want to make it court date, but I don't understand the
Yeah, and see, near court, Adrian said, when you're lawyer, so you cannot represent Nipa way or tribunal on some matter way. And they can Nipa no an application, me boy, appeal on one or another.
I mean,
well, it's on your wood, and I would there.
Mr. Stadia.
Yeah, he was a stand on one or another, even though Ubuano, on one or another, one for lawyer be a me boy.
Yeah.
On one or another, and I'm call court no so one for barrister be a uncle, me boy.
Yeah, for be uncle.
So, good thing is said, Judge, Anchor said no to you, but he will go ahead and hear the matter. Well, I'm trying to adjourn the case, my direction say send all the document. Now document name call that.
No, call that. I say almost for the
okay.
Almost time. Something like that. As that request
yes. And it's a home office for say money document evidence no ye gina swedi asam na there's no way a judge no go ahead. And then number 2 into we dey na akoye 2 1 the rep was being debated in your case, meboa. And the home office for so mun document, into either way, no na judge na say o to asam no eshada. Now case management hono, what now be decide say allow you to rep your sister and now say ma kwan to represent your sister. Say many wa enka imprempren ya no mekwa akopɛ lawyer say uni bibi munja asem na muntu asomayen lawyer no they make application to court say we now represent this client, then all the documents will go. Even crown the lawyer will review the evidence to see say e ben here somebody be account ho because the law will still allow. Now lawyer no afele sa ebre no so a barrister na lawyer no ba fa no obe complete form 84 no section 84 form no straightforward. Say I'm represented as a barrister from these chambers. And I was instructed by this law firm to represent this client. Because you don't have that acquaintance. But what is here? That's a penny year. Mama Madiana Fonkodan lawyer said, I didn't hear to Ashada, Mr. Ramo, won't take it over.
We are patrona so numbers now because they don't agency. I'm not requiring to fair. How much
Mama,
Me say, we know not the good thing is homeless for no, homeless for no. Baby,
Yeah,
Meaning
but
say, yeah,
Omamba,
meaning
but
say,
I just the
yeah,
next time is Omamba.
yeah, it's really number no, and to the mention so competition na make you up. Na ye be up.
Yes, nti wo fra officer na we bisa lawyer na waba abehuye. Why?
There is a lot of men far away, far away.
We can do Zoom or telephone consultation.
Thank you. It means no.
No problem. Number no, it will be on the screen. The message also as well. Why?
You, Brapney, that's a power.
All right, thank you very much. Ubetini Afre, you can call in by 0208-123-1016 or 0739920848. I have Grace Press. Grace Press, you put this comment on YouTube. I'll say, I came into the country on 20th March 2018 on pre-settled visa. Can I apply for my settlement in February this year?
So 19, 20, 21, 22. So 1, 2, 3, 4, 5. Yes, so with the 5 years, I suppose the pre-settled chrono is ending. So your pre-settled is actually expiring. So you got to renew by extending it, and that will be your final application, settled status.
Okay. When you say good afternoon, my question, I know you wanted to say question, but you said quotation. My question is, I have a British child. Her passport has expired, and did so 3 years ago. Would it have any effect on her? Also, I have 2 children. I brought them from Ghana through their dad, as he is married to an EU, but they are no longer in a relationship, and he has permanent stay last year. But he said he will not put in an application for the children. Is there anything I can do?
What about herself? What does she have? We don't know.
No, I don't think. Yeah. Say I have a British passport and my British card has expired 3 years ago. Will it affect any?
The expired one is for the child, isn't it? Say her child's passport is expired.
Expired, yes.
Well, if the child's passport is expired, what it means is that the child cannot travel without renewing the passport.
Okay.
And if the child needs the passport for anything and it's expired, they will ask the child to renew the passport before they can use it. So it's better that the passport is renewed.
Okay.
Because she doesn't know what will be needed, what she will need a passport for as she goes along. Now, the second
question says, the second question, I have 2 children, brought them from Ghana through their dad, as he's married to an EU national, but they are no longer in a relationship. And he had his permanent stay last year. I think that's what he means. But he said he will not put in the application for the children. Is there anything I can do?
So let's assume that she's living with the kids. I don't know who lives with the children, but the children came in, and the sponsor was the EU person. And as we discussed the last time, there has been an intervening factor, divorce. If she said they are no longer there, presumption is that they are divorced.
Okay.
If there is divorce, then there should be evidence of divorce certificate.
Right.
If there is divorce certificate, the children will add it to the application that there has been intervening factor and continue to extend their leave. If the father were to be willing to help, the father has indefinite leave to remain, then the children can depend on the father to make an application for registration. But unfortunately, due to whatever is going on, they have to find another way to deal with this.
Okay. 0739920846. Hello? Hello?
Hello?
Good evening.
Oh, good evening, sir.
Boko there.
Me pacho, pacho yeah, boko.
Good, good.
Pacho,
It's you.
mpese mi bisa. Pacho, good afternoon. Pacho mi bisa papa lawyer sem kaka. Ma. Me pacho yo obi a me ye ejuma full time. And me started say me permanent
We are
night.
Juma full time.
Yeah,
Okay.
permanent full time. Yeah. And I'm
Okay.
sure say me ye night only.
Okay.
2021 June. But to say you're not new manager, be a say on sister or say yeah flexible hours, working hours. But the issue is say mania the friend say I was diagnosed with blood clot in my lungs.
Oh,
And
okay.
say me
You
fa
sent in a text earlier on.
yeah, I send the text.
Oh, okay. Okay.
And this is say
Go
in
ahead.
fact me fa blood thinner medication. And another issue is that we were akwala 11 and the
That
three.
your computer, your TV's volume is interrupting. And if you could
Oh,
either go
sorry.
away from that or just mute it so we can hear you from the phone. Why?
Sorry, I'm better.
Aha, okay, yeah.
Yeah, but I mean, well, 3 years and 11 years old. But me 2 years, no, 3 years, no, sorry. Or a child, special needs child. Until me explaining my almost say, changing to night, and me what child care issues and duties now say me yeah as a father.
Okay.
And I me yeah mixed shift, you know, mean to me. And yeah, because until I me beside me previous management for full time as a night shift only no. But my casa and I'll say on TSC and TSM in your way. But I say me in your meeting I be no. I say me yeah with the union, maybe I'm a union. But I say you be together. But no echo any omoko yeah. Ɔno nkɔyɛɛyɛ ne na ɔmo ɔno nkwa na ɔbaayɛ no ɔbɛka kyerɛ no sɛ ɔmo adecide sɛ ɔmo de mbɛkɔ baabi foforɔ which is 20 miles away from me. And I'm explaining kyerɛ no sɛ mekɔ adwuma wei na mentumi ɛmba ɛmde nkwalaa no ɛbɛkɔ school no ɛbɛyɛ affect me. And driving on the M1 sɛ ɛbɛkɔ wei no nso no it's a risk mami. Say or see me tena fie na me train ba ombe omo arrange for meeting na mpesa me say a different chance and I'm a war.
Okay.
Yo, is he on the
Yes,
line?
on the call.
Yeah, director, it is saying.
Hello, sorry.
Director, it is saying.
I'm Patricia, lawyer.
Good. Since now what if you know, omutia oka.
Patricia, you'll see.
That's good. That's what I wanted to know. So that's refreshing. So wait for them. If they are not paying you, then I would have looked at what you can do. But omutia oka. So wait for them. If it's going to take 1 year for them to come back, let them pay you and wait. Omaka say yes, we have reconsidered, fine. Or they will say no, we are where we are. So Maka you call what we call ACAS. ACAS is the body that intervenes on behalf of employees and employers. Ufra ACAS na waka semni na atrewo. ACAS will advise you, but they cannot force the employer to do otherwise or do what they wouldn't want to do. Don't worry. Just make sure that you are following through the process. After ACAS, still are no man because you have already applied for flexible hours to meet what we call family work-life balance. And in your case, you have a good reason, the needs of your disabled child. They gave you that flexibility. Then another manager or a decision is made to change that, isn't it?
But on the new manager, no say. Also, the previous manager, no, one mama signed a baby. She just said it verbally. Until when new manager no see say mean be express say we are authorizing for my permanent role. Na me email be extra and say me ma administrator no kra na obule me kasa na or play. Until for the past since June 2021, my permanent. They say I'm no buy no all.
Okay. I'm saying, I mean, use technicality against you. Say, then nature say, kasa. Yes, I net here.
But yeah.
Okay. I don't know what you have. Evidence says, sana, I can't say, yeah, no. But either way, no. It is what it is. Into their chain, investigation, as make a decision. However long you be taking a chain. Back, make say fine, and I say still no. Make say no, still for acres. Na kachire won say na ekoso. Na can we circumstance etre won. They will have a word with the employer. The employer is still our say they be let them do whatever they want to do. They will have two options. Either say terminate you completely, and then say force ma wa resign. So force na wa resign here. We call it constructive dismissal. So unforced, but can't say that would be unfair dismissal. How long have you worked with them?
But your March in there 2 years.
March way year 2 years.
But
Into potentially no say say time no take a decision to dismiss you is Satam no way the 2 years there, then you have the right not to be unfairly dismissed. Because Mrane say before we to me enya saa there no just say why you juma 2 years. But what just here? Until a bomb pie say by March I didn't be delay up to April. Then what cover with 2 years. Then either way no you can take action say either wrongful dismissal, unfair dismissal or constructive dismissal. But what I would advise you to do is say BBC no even though it's easy to fight it alone, sometimes it's better to seek the backing of a lawyer. Why?
Union,
What's it?
But your union rep and the union
Now they think a union on committee no one from one could be.
No, but your manager no. And arrange meeting, no, but no catcher said me and me union rep will be informed. But no, and no meeting or back door.
Okay. Meeting. I don't know. Okay.
Anyway,
Anyway, don't worry.
It probably means say or mention say only union rep no ebe from to meeting.
Yeah.
But one free or and no akoye meeting with top management.
Maybe. Okay, so that's fine. You let's leave it. But you have to make sure say sanya wo kan nyina no story no wo ho date na ade ni na ho kama. Why? Na say make decision no said they be hopefully after March. So you could do March there a bit tricky because we won't 2 years yet. But after March, they are now wait 2 years. Until you can assert your right. Ewo emrakwan so say, omo dismissal unfairly. And as I say, one will be resigning so you can say omo aforso ema wa resigning, and that is constructive dismissal. Why?
No, until I also wait till March.
March is in your own interest.
Okay, yeah.
Because since I'm new can say we need 2 years or maybe. So you don't have right under the law to fight anything. But the good thing is that they have not concluded. They have not made a decision to say go home, to terminate him. And see, if they make the decision after March, then he would have had the employment for 2 years. Then under Section 108, he has become a qualifying employee because he has worked with them for at least 2 years. Why?
Okay, Mabala, I'm sorry, and see, the Bia woman, the Emmy will move for for about 20 miles away from me. And see, met to me, I accept it, Namidia, in case I almost say, because meeting almost say, be soon. Be before March. It's met to me, I call her Kakra, Namidi, drew March, I qualify for winner now, and I still.
But some can say call now call. That means what accept say we call 20 miles away. What is here? So you cannot turn around and say Davy. See no I will feel say emwa no. Then you say emwa me because of nientia me de kwaje change no say. Until say me 20 miles away, how do I take care of the disabled child no? Why?
Yeah. But
Okay.
I'd rather say, sorry, but you spending with time. I'll see. Mean throw letter, mean koji in Colano school, a letter for in Colano say, say me the Wamuba, me the in Colano school, Makwakoji, or say me for medical way no sombra, na mention media mano. But in Crawford, or other people were hard. They only have to tell them say, "Oh, we child care," and one or not what they have accepted. Woman, ebi mo nso wɔ hɔ a wɔn si o, so we mix no na ɛma wɔn body no react. Want to mean that they've accepted them, but for some reason, me nkwa it's obi a na ɔyɛ bibi sa.
So feel say sana ekoso there, then you can ubetumi ejina ne awoken so because then that will be discrimination under the law. Because you will be a friend of comparators. Sana pano a wokan asam no and we are the same employee. We employees. So be dear ye tie no keke. Na ye jina so aboano. Na wo dear ye ntie wo na ye se kofa we you kofa background mo si dey be there. Then they are being unfavorable towards you. What you say? Some there you can bring action against them. But either way, no, you have to make sure it's away the 2 years. Away,
All right.
Okay.
Thank you.
Well, thank you too. God bless you. Thank you for having time to be with us on the program. Lawyer, the one that brought in the issue of her children having come through and that says the children have been, it says, the children, I have 2.5 through my child. And she spent 7.5 years on that. So he has another renewal to do on the 10-year route. The children have lived with her since they came through. The one that said has 2 children that was brought in.
Yeah, but so this person has 2 children, one under immigration rules, or because or a British child, or with a British passport, which is expired though. The other one is under Appendix EU provision. 2 kids came from abroad. They have made currently on pre-settled, thinking about how they become settled, and issues have arisen. How do they get around it? She's now saying that she has, she's now in her 7th year on the 10-year route, I suppose.
Yeah.
But which of the 2? I'm sure she obtained that based on the child, the British child, the one whose passport is expired.
I suppose so.
Yeah, I suppose so. So for herself, it's just go and renew the child's passport, use it to renew your visa when your time comes.
Straightforward.
Because this is a child that she's been using, isn't it? Not using per se. She's been depending on to make her application. So if the application is expired or it's about to, the leave is about to expire, she has to renew. Maybe she wants to switch to the EU children.
I think I should be giving this person a reward because as you explained, she comes in with further explanation. She says yes. I think the child is a British and she acquired her status on
Through
the British
that, yes.
So it's straightforward. Renew the passport.
Go renew the passport and continue your application when it expires. Last 28 days to the expiry of the application of your leave. I extend.
Naomi, it's straightforward. Please go do it and you'll be fine. Okay, another one. Mawena Koku says, how do I get my immigration history data from the Home Office? I'm always asked to put in a UK postcode when filling one form on their website.
You make an application for your, so it's called subject access request. You apply for them to give you the information they hold about you. It's a standard form, so you complete it, just like completing any other application to the Home Office.
Okay.
And provide all the information they've asked for. There are 2 of them, standard and comprehensive. So you ask for the comprehensive one. The comprehensive will give you a lot of information as opposed to the standard, which is quite brief or summary.
All right. This one says, lawyer, I'm submitting application for indefinite leave to remain 5 years partner route. Okay. I meet the financial threshold of 18,600. I earn 23,000 pounds per year. My partner earns 25,000 pounds per year. Do I have to include all other sources of income like child benefits and DLA for my child? Is it compulsory to include all sources of income after meeting the threshold of 18,600?
They are separate. Now our friend here has a choice to use 23,000, which is more than the 18,600. And if there are children here involved, I'm sure the children are British children, so she wouldn't even have to consider the children's threshold for maintenance.
Okay.
Then the husband earns 25,000, which is also more than 18,600. So either his husband or both can do the trick. So declare everything. In terms of the benefits and what have you, they will ask you, so you just have to declare them.
But it wouldn't affect the threshold because you meet it.
It wouldn't affect because she wouldn't have to. If she didn't meet that, then she will have to then, her application would have been considered under case law maintenance provision, where the person doesn't meet the 18,600. But you see, the person came as a spouse of a British citizen, so and want to extend on that basis the second 2.5. So it's always the case that if they are able to meet the 18,600, is better. And I'm happy that our sister or brother meets that. So no room for.
I'm going to hazard a response, and I believe I will be right. Naomi is saying that. What about the two children from abroad as their dad doesn't want to get them the indefinite leave to remain? Lawyer said, get evidence that he's divorced.
Yes.
And if you get that divorce certificate, that's an extenuating factor.
Yes.
And you can use that to apply for them.
So the children will retain their rights.
Okay. I'm getting better.
Yes.
What
you always doing that.
Thank you very much. Okay, now let me take this other one. We're running out of time, but we'll take two quick ones and we go on. I'm currently on a student visa and I'm working part-time as a support worker. I am a permanent staff. When I finish with the school, can I tell my employer I want to switch to work full-time since my contract is on permanent basis? Is there a possibility that they would sponsor me to work after school since my contract is a permanent one?
That possibility depends on the employer. So it's not a legal point that a lawyer will have to respond to give to express an opinion.
Okay.
Because I don't know the employer and I don't know the employer's circumstance, and therefore I cannot conclude that there will be a possibility that this employer will decide A or B.
Okay.
So I would say it depends on your employer. What you have to do is to pick up the conversation early with the employer, so that they know your intentions, and you can also assess from their responses whether there will be possibility of giving you sponsorship to be able to continue. If that's not going to happen, then it's a case of advising yourself as soon as possible, because if you have leave now, then you can easily switch if you have to switch.
All right. Now, if I were you, I would ask my colleagues, my friends, and loved ones to come join us, because very interesting, exciting discussion coming from BWF Solicitors on the program, the community and the law. We have the chance for you to send in your voice note, and that's through our text number 07950422780. And as I tell you and I speak, I have one here. Well, let's listen to this one.
Good evening, lawyer and Mr. Ureko. Pacha, me bisa quick question bio. Madam for baby who not frame me or see say care home and in the back room her. And I don't know what happened and or see like CQC a close care home down. And she say affecting in Kratana, yeah, dear man no. Because say like yeah, cancel the Kratano like if you can see him for no letter or much I think say he almost send the email could see ni pakrona or yeah a man from Ghana no it is email no it is say I can't 10 days either so be page him for to change his contract and now so be call back to Ghana. And I don't know, is there any way, is there any other option or bet me I have apart from getting another job, is there any other option? Midase nyame nhyira mo. Thank you. Bye.
Right.
Unfortunately, it's one of those episodes where it is what it is.
Right.
The employer does not have a license to continue employing this person. So the sponsorship is no longer valid, so to speak. What do you do? This is a peculiar case. What I would advise our sister to tell the friend to do is to seek, to approach a lawyer, seek specific advice.
Okay.
Because this is not a case where you can offer open advice, because it wouldn't really solve the problem. So if, for example, she speaks to a lawyer, the lawyer would delve into it and offer different options. But on the face of it, unfortunately, the sponsorship is questioned, and she cannot continue to work. Because if the Home Office has written to you, then what they are saying is that I don't even know whether the leave has been cancelled. We don't know the content of the letter.
It's about 10 days more to go.
10 days to expire, or 10 days, or maybe they've written to say that switch. So sometimes they will advise you, yes. Yeah. So if you've been advised to switch, then you know what to do as soon as possible. So the person has 10 days to act, yes. But the person is asking, is there any way? That other way, as we speak, if the person were to have a child who is British child in the UK, then the person can argue that if she is asked to remove from the UK, it will affect this British child. But I'm not sure whether this person has that flexibility in terms of relying on her British child. So if there's no British child or EU child in question, then it will be difficult to switch to, let's say, FLRFP provision. Again, the person has not spent 20 years in the UK, so they cannot make application based on private life. If the person decides to apply for a student visa, they have to get admission, go back to their country, and apply from there, potentially. Or they can, but 10 days will not even be enough to get admission and to even switch to student here in the whilst you are here.
All right.
So the options will be based on when you visit a lawyer and the key facts you lay before the lawyer. The lawyer may be able to explore some of these options and see how best. But as we speak and here and now, you have to switch.
Switch, speak to the lawyer. Let's see the very last comment there coming from YouTube. Let's see what it says. What can I say to thank you, BWF Solicitors, for the good job you have done for me? May God Almighty bless you all and open a good future. Yao, Chumesi Ankra. Yao, thank you very much for boldly coming out to say what you have had as a benefit from BWF Solicitors. If nothing at all, every Saturday, if nothing at all, every Friday, if nothing at all, every Thursday, we have the lawyers devote their time, minimum of an hour, to explain to us what we need to know, explain to us what is baffling us, and give answers, provide updates and everything. That's what BWF Solicitors does. And listen, you can't get it anywhere else. They have invested in the community and they are going with us all throughout. For 30 years, BWF Solicitors has been serving the community. That's why we say they are trusted partners when it comes to the law in the community. BWF Solicitors, 0208 493 7340 or 077 127 61884. Now, I will move us quickly to our next segment after this short interlude, and we'll be going for our quiz. We'll be right back. Well. It's our time. We had our quiz competition, and that is the segment I really would want you to participate in the sense that it tells me that whatever knowledge we all acquire, we use it and we can bring it back to memory and apply it when we have to. Now, BWF Solicitors has sent me a question and I want to pose it. So those of you out there, get ready. Sabi, I have your extra question, but I'll be leaving it later on. Naomi, Beauty, God is good, Ni Yabua, William Adolfo, Idrisu Suleiman, Charles Yabua, George Chumasi, Glorious, Tilly Duma, Nanakwekum, Imeye Dede, Doka Sadom, and all the other people I have on. I have Kenneth Antobam, and I'm risking getting into trouble. Abna Ativo, you're also there. Thank you all very much. But I'm expecting all of you to participate in the quiz. Now let's read the question. It's on the screen. Araba and Kuku are Ghanaian citizens. They married in Ghana under the Fanti customary law in 2012. In 2018, they moved to England as lawful residents. In 2020, their marriage broke down irretrievably. They both instructed their respective families to obtain customary divorce for them. This was done by their family elders, pronouncing the marriage dissolved after the necessary customary rites. They obtained a certificate from the Accra Metropolitan Assembly. Kuku has met another woman he wants to marry. Can Kuku use the certificate for the Accra Metropolitan Assembly as evidence of the lawful dissolution of his marriage to Araba in the UK? Now the scenario again, quickly. Araba and Kuku are Ghanaians, citizens. They married under the Fanti customary law in 2012. 6 years later, they moved to England as lawful residents, so they are habitually resident here. And they are domiciled. They have been domiciled in the UK from 2018 because it says lawful residents. Okay. Now, in 2020, unfortunately, 2 years after they become lawful residents, their marriage broke down irretrievably. They both instructed their respective families to obtain customary divorce for them. This was done by their family elders, pronouncing the marriage dissolved after the necessary customary rites. Now, to make it official, they said, okay, let's go to the local assembly or the Accra Metropolitan Assembly, the local authority of the area they lived in. They obtained a certificate from there to say that, oh, the families have met and they have decided that the marriage can't continue anymore. Kuku has met another woman, and he wants to have her as the wife. Can he use the certificate from the Accra Metropolitan Assembly as evidence of the lawful dissolution of his marriage to Araba in the UK? 1 says, yes, he can. 2 says, no, he cannot. Now, flow the answers. Let's go. So let's see what you have. You can text 0795042278 or can put it on the platform and we'll pick it up. First of all, Naomi Bua. No, he cannot. That's number 2. Naomi, thank you. Who else is coming? I mentioned names and I'm expecting all of you to come back. Don't run away. Okay. Emmanuel Sechi, thank you. You have always been with us on YouTube. Thank you very much. Emmanuel says, no, he cannot. That's number 2. Okay. Now, who else is coming? Who else is coming? I have 2 more minutes to pick up your answers before lawyer explains the answer and draw the curtains down at exactly 6 o'clock. Abena Ativo, number 1. Yes, he can. Abena says, yes, he can. Okay. A minute more. Let's see who else is coming. 0795042278 or put your answer in the comment section on both our YouTube and Facebook pages and we'll pick that one up here. Okay, next one, William Sakwadie, number 2. Willie says he cannot. Kuku cannot. Okay, now let's go to the next one. Daniel Osu says number 1, yes he can. Danny? Yes he can. Andrew Ntiabwaji, no, he cannot. That's number 2. No, he cannot. Okay. One more, and I'll go to lawyer. One more, and I'll go to lawyer. Who else is coming? Now, okay, yes, I've got the final one I'm looking for. Grace Press, yes, he can. That's number 1. So I've got it so split, right down in the middle. Yes, he can. No, he cannot. No, you can't sit on the fence on this one. So, lawyer, let's see. Look at the scenario abroad. What can or cannot be done?
Okay. So what we have to understand is that Kuku and Araba married under customary law from their country in their tradition, where the marriage was accepted between the families. For whatever reason, the marriage cannot continue.
Right.
At least one of them or both of them live in the UK. So all they have done is to send a message to their family that we cannot continue, take their drink back. Araba will be the one to send the drink. Araba takes the drink back.
Would have taken a,
Then they go to AMA to say, give us something to show that they are not together anymore. Ideally, that's the end of the matter. However, anybody can do that to the disadvantage of the other person. If Araba does that, it will affect Kuku unduly. And if Kuku also does that, it will affect Araba unduly, because one of them can hide behind the local assembly and get something. By the time the other person realizes they've been divorced without knowing. So it has to be open and bare. So what the law is saying is that they have to go to Ghana court and declare their intention to dissolve the marriage. The court will have to follow the court process to accept to dissolve the marriage. And once the marriage is dissolved, the court will declare and issue dissolution approved by the court with the court seal. And that is the one the UK court will accept. And that is the one Home Office will accept. The reason is that one of them lives in the UK habitually. And in their case, they've been living in the UK since 2018. So they are domiciled in the UK. So they cannot just go to AMA and get something to prove that the marriage is dissolved. They need to go through the court system in Ghana. If they decide not to go through the court system in Ghana, then they have to go through the court system in the UK. It's also allowed. Because they are living in the UK, or one of them at least is living in the UK. They can go through the court system in the UK to get it dissolved. If they don't do that, then they cannot use this as evidence of dissolution so that the other person can be free to remarry. And therefore, the answer is no.
The answer is no. That's number 2. So those of you who gave me the answer as number 1, unfortunately, that's not what the situation is when it comes to the law. Well, it's been very exciting. As usual, I'm going to ask a lawyer to do his 1-minute summary. Unfortunately, that's a test. I'm going to give to the lawyer. So we'll do his 1-minute summary and we draw the curtains down because we have already run out of time. Lawyer.
Thank you very much. So viewers and listeners, today we have touched on a very important point. Point number 1, if you are in the UK and making an application for settlement, you now have opportunity to apply using the priority service. If you want it within 1 week, you pay 500 for each applicant. If you want it within 1 day, 1 working day, or 5 working days, that's a 500. If you want it within 1 working day, then you pay £800 for each applicant. You cannot pick and choose, where one will go for 1 week or 5 days and the other would want 1 day. You all have to make a decision to go this way or that way. There's also opportunity for those abroad to make priority applications. And when you are booking your appointment, you have opportunity to book priority service. Priority service here is the service that the Home Office will render in terms of making the application decision. We also looked at the nugget, and the nugget is very important for one reason. Most people, for whatever reason, their marriage is dissolved or ended, and they have remarried and they want to bring their spouse from abroad. If that the divorce certificate you have is not obtained through the court, Home Office will not accept the divorce, and therefore they will say you cannot remarry and bring your new wife or new husband. So let's take note of that. Now, on the substantive, today we looked at whether you can vary the terms of your contract as an employee so that you can go for flexible working pattern. And the answer is yes. We've looked at Section 80F, Section 80G, HI, what you can do when it happens like that. You have to then apply to the employer or make application to the employer to request that you want to change from A to Z. Either you want to change the hours, you want to change the number of days, you want to change the place of work, but you have to make it clear. You also have to specify in the application the impact of that decision on the employer's business and also show how, in your opinion, that effect will be mitigated or addressed by the employer. So it's very important. Once the application is made to the employer has 3 months to make a decision and to give you feedback. If they cannot, the employer must speak to you and agree a time frame or extended time frame. If that happens, the employer will either say yes or no based on business needs, impact on the business, impact on finances of the business, and so many other factors. If the employer says no without good reason, then you have opportunity to go to court for court to make a decision or what we call make an order for reconsideration or make an order that the employer is right or wrong. If that is done, then you have remedy in court for compensation for what the employer did or what the employer failed to do. So today we have been able to address that point, and we have understood that if your circumstances changed, for example, based on family circumstance, based on childbirth, based on childcare, based on disability of your children, based on education, studies, whatever it is, you can seek the employer's support to vary your employment contract. This is what we have covered today. In any case, you can speak to ACAS, Google ACAS, ACAS, and you have a lot of information. You can speak to them on your employment matters. Speak to your union. You can also speak to a lawyer in terms of your employment matter. Thank you very much for keeping faith with us once more.
BWF Solicitors are trusted partners when it comes to the law. And when it comes to BWTV, we bring you quality unsurpassed in the community. We'll be back again same time next week with another edition of the Community and Law. On behalf of my studio director and manager, Professor Ade, who was the employee of the month December 2022, and also to Sheila Ankara, Patmo Dudu, the ton of lawyers that we have at BWF Solicitors, from everybody to everybody. I want to say thank you so very much for your time with us. Those of you on BW Radio, I know it's gone off and you are tuned into the news from Ghana. Fine. But those of you on Facebook and YouTube, yes, we're having our conclusion and saying our thank yous to all of you. Have a good evening. I love you back. And we will see you again, same time next week. Good evening.
Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, yeah.